Good afternoon, everybody. My name is Trip Vanderwall, and welcome to the Benefits Lunch Break on October 20. We hope everyone is having a great day, and we'll get started here. Again, just alerting you folks of the upcoming lunch break series. We have 2 more remaining in 2021. I can't believe we're saying that already. This year seemed to go pretty fast. But to remind you, they are on the 3rd Wednesday of every month at 12 p.m. Eastern time. So the next 2 scheduled dates will be November 17 and December 15. As always, please feel free to submit topic ideas of topics that you would like us to discuss. At this point, we're really at no loss for items to discuss, especially in the health and welfare world, but we like to hear input from you. And again, we will try to announce our topics at least a week in advance, and we'll get that sent out, and so that you guys can decide whether or not these webinars attending the webinar would be valuable to you. That said, if you have to miss any webinars or you have to log off early, shortly after the webinar is completed, we do post that on the firm's YouTube page, so you can always go back and check that out. For today, we are going to be addressing a year-end benefits checkup, kind of the checklist of items you need to think about now that we're approaching the end of the calendar year, both with respect to retirement plans and health and welfare benefit plans. Going first, we have my partner, Frank Barradin. He's going to be addressing the retirement plan issues. And Frank actually has another commitment at 12:30, so we will probably take a pause to the extent that he has some time after his session before moving to mine to respond to any questions that you may have. And then when those questions are answered up, we'll kick it over to me and I'll address the health and welfare section. Without further ado, Frank, take it over.
Thanks, Trip. When I agreed to speak with Trip on this webinar back in July or whenever it was, it seemed like there were going to be more things that were important issues on the retirement side at the end of the year this year. Then once I put together my outline, I realized there aren't as many. So that's good news for most of you, since it sounds like you are dealing with a number of issues on the health and welfare side. But there still are a few things that I want to make sure people are paying attention to and don't miss potential opportunities. So the first one are the new safe harbor deadlines. And I have new on there, even though they were technically in place, in effect for last year as well. But I think a lot of people are still not adjusted to the new deadlines. And so you still have kind of the contingent safe harbor option for 2021 in 401k plans to avoid your ADP testing and ACP testing by making a 3% non-elective contribution. And if you are interested in doing that, you have until December 1st of 2021 to make that election. And the big thing that changed under the old rules is you would have had to give a contingent notice before the beginning of 2021 in order to take advantage of this. You no longer have to do that. So as long as you have a 401k plan that is tested ADP or ACP test on current year data, then you still can make that election by December 1st, 2021, as long as you amend your plan and eliminate your non-discrimination testing on the pay deferrals and matching contributions for 2021. So any employer that thinks maybe has run a projection or anything and looks like it may be failing this year, feels like it intends to make an employer contribution anyways, that's something to keep in mind because you still have time to do it. Now for 2022, if you use a safe harbor matching contribution, you still do have your December 1st, 2021 deadline to notify the participants of that provision. So those rules didn't really change when you're using the matching contribution to satisfy the safe harbor. So you got to be thinking ahead on those and make sure you take action by December 1st of this year in order to have your safe harbor for next year. And then the third alternative is if you're willing to make a 4% safe harbor non-elective contribution, you actually have a full another year. You have until the end of 2022 to make the election for 2021. And if you're thinking about this retroactively, you actually still have time to make that election for 2020 if you decided that, oh, we have some extra cash, we want to make a contribution for our employees, we could still do that for 2020. I have run into some, seems like a lot of record keepers these days are having trouble, of course, with staffing like everybody else. And some clients that are just now getting their first testing results for 2020. And so if there's a surprise there and it turns out you're failing and still, don't want to have to make refunds or make qualified non-elective contributions, you could conceivably still do the 4% safe harbor non-elective for 2020. So those are some deadlines to keep in mind if you have issues on your ADP or ACP testing. The required amendments for 2021, and the good news there is there really are very few. One is the hardship distribution amendment. These rules have now been in effect for at least 2 years. You had some ability to determine exactly when you wanted to apply them to your plan, assuming your plan allows hardship distributions. But even though they've been in effect, the amendment has not been required until the end of 2021. So make sure if you have not adopted that amendment yet that you do so. And included would be any discretionary amendments you've made for 2021. You could have been operating your plan in accordance with a discretionary amendment that you made, and you didn't have to adopt the amendment until the end of this year, but you need to make sure you do it now by the end of this year. You may also be aware that all defined contribution plans have to be restated, generally pre-approved plans by July of 2022. So in many cases, it makes sense to get that done before the end of 2021 if you're also having to do the hardship distribution amendment or have any discretionary amendments. If you don't, then certainly can still wait and have it restated in 2022. Another thing I'm going to talk about, even though it's not a year-end deadline, but it's just been coming up so much lately that I think everybody should be paying attention to it as soon as possible. And that's the whole cybersecurity issue in 401k or any kind of retirement plan, really. And more out there, I'm seeing record keepers who are providing so-called participant guarantees to participants. And it sounds wonderful when you see participant guarantee. Oh, if anybody steals the money in my account, they're guaranteed to put it back in as long as I didn't do something really, careless and give my password to somebody else or things like that. But when you look at the fine print, most of those participant guarantees aren't worth the paper they're written on. They have all kinds of exceptions. They have all kinds of ability of the provider, the record keeper, to only pay out as much as they think they should, or and it's kind of in their complete discretion. So I'm definitely recommending to clients that they look very carefully at their service agreements, make sure that their record keeper really is on the hook for any losses incurred by the participants, so long as neither the participant nor the employer were negligent. And that's kind of the gold standard. There are a number of record keepers that have been unwilling to do that. They make it pretty darn clear that they don't feel like they can protect the participants' assets, even if the participant and the employer are not at fault. Obviously, that's a big concern. And so employers need to understand if their record keeper is not doing that they may have to close down some of the online options and things that are available under the plan to provide additional protection for the participant. But the much better alternative, of course, is to convince the record keeper or find a different record keeper who will provide a true guarantee to the participants. Another thing that actually is kind of a year-end deadline is the Department of Labor's fiduciary rules. And those are really in effect now, but on December 20th, there's a no enforcement policy currently in effect that will expire on December 20th. These rules are important because any advisor, financial advisor out there who provides a recommendation for a participant in any of your plans to roll their money to another plan or to roll it to an IRA, that's considered fiduciary advice. And that means that the person providing that fiduciary advice, the financial advisor, if they receive commission or any compensation as a result of that recommendation, that's a prohibited transaction. So there is a prohibited transaction exemption available to them so that they can get compensation for making that recommendation, but they have to provide the participant with significant amount of information about why they're recommending the rollover. This is a very good thing, I think, from the participant standpoint, because we all know many of our clients have had good retirement plans. People accumulate significant amounts of money, and then they roll it over based on some bad recommendation, and they start paying much higher fees and getting bad advice, and then they end up, not having near the retirement income that they would have if they had left the money in the plan or made a better rollover decision. So the reason that you need to be aware of that is that these advisors need to get significant information about the plan in order to determine whether the participant is truly better off by rolling over the distribution. And that includes fee information, investment option information. So I think you just need to be aware of that, because assuming these advisors actually want to comply with this and avoid significant potential penalties, I think you're going to start seeing a lot more of these requests coming in so that they can get the information they need and avoid a violation. Another thing that I just am going to really quickly mention are the 2022 dollar limits. They have not been officially released by the IRS yet, but in the past, the projections that have been provided based on the formula used to determine them has always been correct. And here they are, the 401k limits going up by $1,000, the maximum compensation limits going up by $15,000, the maximum defined contribution, total contribution is going up by $3,000 from 58 to 61, and the highly compensated employee definition is going up from 130 to 135. So in any communications that are going out to the participants, you'll need to reflect these new limits that will go into effect next year. And the last thing I'm going to talk about is the backdoor Roth conversion. Like so many things, this was getting a lot of attention this year, partly based on a Wall Street Journal article that a number of our clients, were sending to us, and everybody was paying attention that had read that article because it sounded so great. Make after-tax contributions to the 401k plan, then immediately convert them to Roth, and you've essentially allowed a much higher limit on your contributions to retirement plans as either Roth or pre-tax. And it worked in some cases, but the article was very misleading and made it believe that every plan should do this. But many of our clients and other plans did take advantage of this. And because it became so popular, of course, then Congress immediately wants to shut it down once they find out that there's a significant loss of tax revenue. So there's a proposal, part of the Biden's proposed plan on infrastructure and things, to raise some revenue by closing this opportunity, especially for high income individuals, though it may end up being closed for all participants. So I bring it up mostly because in plan restatements, we were starting to add it more because it did seem like in certain cases it was beneficial. But now, if participants have made these after-tax contributions in 2021, you want to be sure to advise them to make sure they convert it to Roth before the end of 2021. Otherwise, they may lose the ability to do that. And after-tax contributions, if they cannot be converted to Roth, really are not good investment. I mean, they're better off not doing it if they can't convert it to Roth. So if they have already made those contributions, you want to advise them that they should make sure they do the conversion before this option goes away at the end of this year. That's all I have on the retirement side. So pretty light year this year, which is good.
Thank you, Frank. I don't actually see any attendee questions, but I have one for you, if you wouldn't mind answering. And maybe this is unfair, and if you don't know the answer, I certainly understand. I know some of these changes that you just talked about are potential, are part of, I think what's currently the $3.5 trillion reconciliation bill that's being negotiated. But I know there's also does that reconciliation bill currently include this so-called Secure Act 2.0, or are those still separated as far as you know?
Yeah, I have not seen that the whole package has been included in there. It seems like I've seen some of the things, but as we know, that those bills always evolve so much in the process. So I'm not sure how many of them may make it through, but certainly it's worth keeping our eye on because there were some fairly significant proposals in there.
When we also we'll have an appropriations bill coming up, and just by way of example, the Consolidated Appropriations Act of 2021 ended up, at least for health and welfare, kind of ended up like the kitchen sink, where they had taken a bunch of separate acts that had not had much traction, like the No Surprises Act and other transparency requirements for health plans, and kind of just threw that in the Consolidated Appropriations Act, which was signed on a Sunday night on December 27. And as I was paging through it yet that night, I just thought, wow, there is a significant amount of provisions that are impacting health and welfare plans that I wasn't necessarily suspecting to see all of a sudden. So I think, I know the Secure Act 2.0 is still out there, but sometimes those things can get bundled up, in short order at the end of the year and pass through some larger bill.
Yeah, it's certainly the same experience on the retirement side with the multi-employer plan legislation that passed earlier this year. That was a big surprise to a lot of people, and the same kind of thing. It was just thrown in, completely unrelated bill. And so it wouldn't be at all surprising to see that happen again at the end of this year.
All right, thank you, Frank. And now we will move on to the health and welfare section. Let's talk about notices. There are various annual notices that must be distributed related to group health plans. And frequently, even though not all of these notices are necessarily required to be distributed during the annual open enrollment period, the annual open enrollment period is a convenient time to do so. And since a large majority of plans are calendar year plans, we are in open enrollment season right now. So I just want to cover some of these notices that may be applicable. Now, having said what I just did, the summary of benefits and coverage is a notice that is required to be distributed during the annual open enrollment period. So that's the one exception. The rest of them are just annual notice requirements. And so convenience would say probably do it during the annual open enrollment period. Next one is Women's Health and Cancer Rights Act notice. This notice is often contained in the SPD, but if you're not distributing the SPD annually, you should include this as a standalone notice or combined with your other notices in your open enrollment period materials. HIPAA notice of privacy practices. So technically, this is required to be distributed upon a participant's initial enrollment and then every 3 years thereafter. But there's actually a little technicality that you can get out of distributing this notice kind of can distribute it initially and then only upon request or when it changes. And basically, if every 3 years you at least notify the participants of the availability of the notice and how to obtain a copy, you don't actually have to give them the actual notice. So what we typically recommend, again, is in your standard notices that go out in annual open enrollment materials, statement about how privacy is important to you. We maintain privacy according to HIPAA. For more information, we have this notice of privacy practices that can be obtained at any time by calling or contacting yada yada yada. And then you don't have to distribute the full HIPAA notices privacy practices every year or even every 3 years. CHIPRA notice, which is for residents who live in a state that provide premium assistance arrangements. And these premium assistance arrangements generally fall under CHIP or state Medicaid. And essentially the state where individuals are eligible for employer provided group health coverage, but maybe can't afford it, they will help the employee pay the premium for that coverage to keep them off the state Medicaid roll. So in states where you have these CHIPRA or Medicaid premium assistance arrangements, there is an annual CHIPRA notice. Currently, Michigan does not have one of these programs. So if you only have employees living in Michigan, this is not a notice that you need to comply with. One other thing I'm going to mention about this CHIPRA notice is that the DOL updates it twice a year, every January 31 and every July 31. Every year when I review my clients' open enrollment materials, I find some that have an old notice. And while there may be very few changes between versions, I always encourage using the most recent version, because there's a lot of contact information to state agencies, whether it be by telephone number, email, those are constantly being revised. So again, you can Google DOL CHIPRA notice and it brings you right to the most recent notice. So just, and right in the top, I think the third paragraph, right before where kind of the chart starts, if you know where this is, it contains the date of the notice. So just be sure you're using the most recent notice. Medicare Part D, creditable or non-creditable coverage notices for plans that provide prescription drug coverage. That should be distributed at least annually upon any other changes and on request. And keep in mind that this is a kind of only one part of two of the Medicare Part D reporting requirement. You have to also report certain information about a plan's creditable or non-creditable coverage to CMS by 60 days after the first day of the plan year. So for plans that are calendar year plans, that CMS reporting obligation usually land, I think technically if you do 60 days in a non-leap year, it's March 2, but I typically always just say March 1 for convenience. For those plans that have wellness programs, keep in mind if the wellness program is subject to HIPAA, so it's a potentially discrimination based on a health factor, all plan materials that you have, to the extent that the wellness program is not just a participatory wellness program, must include the availability of a reasonable alternative standard or a waiver of the standard. And this has become a real big issue, I think, this year more than others, because we have lots of employers that are looking at imposing these vaccination incentives that are tied to the health plan. So if an employee is vaccinated, they may either avoid a premium surcharge or be entitled to a premium discount. Those are HIPAA outcome-based, specifically activity-based wellness programs, and anything describing that has to have this disclosure about an availability of a reasonable alternative standard. If the wellness program is subject to the ADA, there's a model notice that should be provided. The EEOC has provided that model notice. And if the wellness program is subject to GINA, there's not really a notice requirement, but you have to get the employee's prior voluntary consent to obtain collection of the employee's genetic information. And in this situation, that's usually medical information of the employee's spouse that is filled out on, for example, a health risk assessment. And that medical information is actually genetic information of the employee, which is really weird and perverse, but the way the law defines is, your spouse's medical information is actually your own genetic information. Moving on, one new notice, and I think there's a little bit of uncertainty here, is this No Surprises Act notice. The regulations or the law actually state that this notice must be made publicly available, posted on the public website of the plan, and included on each EOB. At this point, it's not clear what publicly available means. Does that mean we have to include it in the SPD? We have to include it in the open enrollment materials? I will tell you, after watching, and there's no statutory requirement that it's in either one of those options, but after watching a webinar just yesterday with a government attorney on it, who really kind of was harping on the fact that, it is a plan sponsor's obligation to educate their employees about the new protections under the Consolidated Appropriations Act, which includes this No Surprises Act. I'm leaning towards, as I'm restating plan SPDs for 2022, to include that model notice. And there's also a standalone notice that if you want to, really take the conservative approach, you can put it in your open enrollment materials. I'm not saying that's required, but it certainly wouldn't hurt. You wouldn't be penalized for doing that. Plans don't typically maintain a public website, so there's not necessarily, I don't know if that's too applicable. But again, on this webinar that I've sat on, DOL and other government attorneys have said, well, if you have an internal website, like an intranet site, or electronic benefit enrollment platform, and you can post it, it probably wouldn't be a bad idea to post it there. And then, of course, I would expect that if you're a fully insured plan, your insurer will be posting it on its website. And maybe you want to talk to your TPA of a self-funded plan to see if they're going to post this notice on its website. Specifically, it maintains kind of a sub website for your plan participants specifically. SPD updates. So obviously, as you make plan changes that impact the SPD, those should be rolled in. And plan design changes are typically made, they can be made during mid-year. They are more often made from one plan year to the next. So again, while there is some timing, lag timing that you can, or different ways you can do this, whether you do it by summary of material modification, or you generally have about 210 days to the extent that the plan change is not a material reduction in covered services or benefits. But if you're restating your SPD for the next year and you got plan changes that impact it, those should go in there. Legal changes, and again, let me just note here that there's no specific legal required notices under the Consolidated Appropriations Act, but these are all protections that we'll kind of quick go through that stem from this Consolidated Appropriations Act. And again, after attending this webinar and hearing the government attorney speak, I'm more inclined to, while we're restating SPDs for 2022, to include these provisions. Again, the No Surprises Act model notice, maybe a separate statement of the No Surprises Act protections, which of course apply in the context of emergency services, non-emergency services provided at an in-network facility by an out-of-network provider, and then air ambulance services. Modify your external review requirements, because those now have to include, basically the definition of adverse benefit determination includes a situation where a participant may question whether the plan is complying with the NSA protection. So if there's an event where they end up getting cost sharing that's based on an out-of-network rate where they felt like the NSA protections applied, that determination is subject to external review. And actually that is going to apply even to grandfathered plans. I know we don't have a lot of those. Grandfathered plans are generally exempt from the external review requirements, but in this kind of little tweak, there is no grandfathered protection to CAA, or Consolidated Appropriations Act changes. So if you're in a grandfathered plan, maybe we need to even add the external review rules only for this purpose. Protections for relying on inaccurate provider directories, and I'm not going to cover this in great detail, but generally, beginning 2022, if I go to an out-of-network provider, but I had consulted with my plan's provider directory and understand, I was told that it was a network provider, basically the plan has to pay for those services as though it was provided by an in-network provider. And then certain protections for what we call continuing care patients. Again, we may be addressing some of these in more detail in future webinars, but this is just kind of what I think we should probably, if you're restating your SPD for 2022, things I think you should consider adding in. And it may be that if you're relying on a TPA, for example, of a self-funded plan or an insurer for a fully insured plan, they may be rolling a lot of these notices into either the certificates of coverage for fully insured or the SPD for the self-funded plans. Section 125 cafeteria plan amendment. So about last year at this time, we did a couple webinars about various IRS guidance and Consolidated Appropriations Act changes that greatly expanded flexibility for employers to allow, but did not require them with respect to both elections under Section 125 plans and FSAs, specifically with respect to the FSA lose it or use it rule. The deadline to formally amend Section 125 plans for these changes is the last day of the first calendar year beginning after the end of the plan year in which the change took effect. I realize that's a mouthful, but by way of example, if you have a calendar year plan, you implemented by administration some of these changes in 2020. Well, the first calendar year that began after your 2020 calendar year is 2021. And December 31 being the last day of 2021, that is the deadline to formally amend your Section 125 plans to include those changes. Form 5500. So this is a little bit further out there in the future, especially for calendar year plan years. But if you have a health or welfare benefit subject to ERISA with at least 100 participants, as of the first day of the plan year, a Form 5500 is required to be filed by the last day of the 7th calendar month after the end of the plan year. Keep in mind that a 2.5 month extension is available. Getting back to the notice requirement, if your plan is required to file a 5500, you also have the summary annual report or SAR requirement, which is basically a short summary of information that is reported on the Form 5500. And that generally has to be distributed to participants within 9 months after the end of the plan year, which you get an additional 2 months if you file for an extension of the filing of the Form 5500. Which of course makes sense because if you file for an extension, you may not actually have the Form 5500 prepared by 9 months. COBRA, the one thing I forgot to put on the slide is, again, I reminded folks that attended our employment law session, the outbreak period continues. So all these COBRA delays, HIPAA special enrollment delays, they continue, and I would think probably will continue for the foreseeable future. But keep in mind, if you are about to go through your open enrollment period, COBRA qualified beneficiaries who are actually enrolled in COBRA coverage, they have the same rights as all active employees. So, you need to be sending them your open enrollment materials and allowing them to make changes. And that even includes potentially new benefits. So let's say I'm an employee of XYZ Corporation. I'm enrolled in just medical. I'm not enrolled in dental and vision. I terminate employment for reasons other than my gross misconduct, and I elect COBRA. I come up to the open enrollment period. Not only at that point can I switch which medical coverage I'm covered under, I also have the opportunity to elect vision and benefit or vision and dental coverages for myself or my other eligible dependents. So keep in mind, as you go through your open enrollment, don't forget about those COBRA qualified beneficiaries. The COBRA subsidy was not, under ARPA, which was a big topic this past spring, was not extended. I think so. We're kind of done with that administration, but keep in mind that when you provided those COBRA subsidies, you're eligible for a tax credit against your payroll taxes to offset for your costs for that. So subsidies provided in July, August, and September must be claimed on the third quarter payroll tax return, which is generally the Form 941. And my understanding is that deadline is coming up relatively quickly. MLR rebates. So if you are a self-funded plan, you can kind of check out for this slide. But for those of you with a fully insured plan, the MLR rebates are generally paid by the insurance company, if applicable. Not all insurance companies will have to pay them in September, sometimes late August, sometimes September. The reason I bring that up is under ERISA, to avoid ERISA trust and prohibited transaction rules, you generally have 3 months from the date that you receive the MLR rebate from the insurer to use the portion that's attributable to participants and is quote unquote a plan asset for plan participants and beneficiaries, including in some cases, former employees. So you got 3 months, so don't just sit on those. Again, as a quick reminder, permissible uses are cash refunds to those participants, premium holiday, which I kind of see as, two different sides of the same coin. If I'm just giving you a cash refund, obviously that's straightforward. But if I say, you owe $100 per payroll period for your health insurance, now I'm going to cut it down to 50, that's going to make my taxable wages go up by $50. So I think that's, again, very similar, or other quote unquote benefit enhancements, whatever that means is not entirely clear. Looking ahead, so this is not necessarily year-end stuff, but this is stuff that that you should be aware of or back on your radar. And I'm imagining if I was doing this in person or I could hear the folks on the line, there would be a collective groan when we talk about forms 1094 and 1095C. I think these people are largely familiar who are subject to these reporting requirements. Keep in mind that they just must generally be furnished to participants by the first business day on or after January 31. So for 2021, that is Monday, January 31, 2022. Now, the IRS has historically delayed the deadline to distribute these forms to participants until early March. However, last year when the IRS issued guidance extending the deadlines for 2019, they indicated this may be the last time they extend it. And they also indicated they may be the last time they extend this good faith, reasonable compliance relief from penalties. So keep in mind, we may actually have to get these forms out to participants by January 31, or full-time employees by January 31 of 2022. Must be filed by, and for 2020, it's going to be filed by February 28, 2022 with the IRS. If you file by paper, which I think is somewhat rare. Now, keep in mind, you're generally required to file by electronically if you file more than 250 of these forms. The IRS this fall proposed some regulations that said, hey, when you determine whether you file 250 forms, we usually let you count all your IRS forms separately. We think we're going to change that. So we're going to combine a number of these forms. And if you aggregately, you get over 250, you're going to be subject to the electronic filing requirement for all forms. And most importantly, it's going to be these forms 1094C, 1085C would be aggregated under the proposed regs with W-2s, which I think will push a lot of those folks that are under 250 over that 250 and require some electronic filing. So if you've been filing in paper, keep in mind that at some point in the future, you're probably likely going to be forced to move to electronically. Those regulations are still in proposed form, so they're not effective yet. So it's theoretically possible for the 2021 forms 1095C, but if I had to bet, I think it would be later. When you're filing these forms electronically, the deadline for the 2021 forms will be Friday, March 31 of next year. For any of you, those are MIWAs or multiple employer welfare arrangements that are subject to this annual Form M1 filing requirement, that is going to be due on March 1, 2022. And keep in mind, I have a couple clients who I have to work with to file these, and every year when I file the annual one, they let me know of a few changes from last year. Just to note, if you are subject to this requirement, the annual form is generally not the time to report changes. Rather, these changes will often trigger a mid-year Form N1 filing requirement that was due within 30 days of the date of the change. So again, if you've had any changes specifically to what falls in Part 2, which I think is the financial and custodial information, we need to maybe have a mid-year filing that's already going to be late. HIPAA reports of breaches of PHI that occurred during 2021 that affected less than 500 participants have to be reported to HHS by March 1 of 2022. Of course, if you were unfortunately had a breach that affected at least 500 participants, that had to be reported to HHS basically as soon as it reasonably possible, but no later than 60 days following the discovery of the breach. With that said, let's go back to some notices. Is a CHIPRA notice required for employees living in another state, i.e. Ohio, but employed by a business located in Michigan? The answer is yes. It does not matter where the employer resides. It matters where the participant resides. So if the participant resides in a state, and I do not know if Ohio is one of those states, you would have to distribute those CHIPRA notices. So I do have a number of clients who have employees that reside in different states, even if they're primarily in Michigan, who will just send out the CHIPRA notice to everyone, and that way they don't have to, be distributed to they don't have to have kind of like custom open enrollment packets, for each different state. Does the chipper notice go to an employee address or a child address, if not with the parent? I think technically the answer is kind of like a lot of notices. If you have no reason to believe that there's participants in the health plan that are not residing with the employee, then provision of that notice to the employee is going to be sufficient. But if you know that you may have a participant that resides in a different address, then there's likely an obligation to send it not only to the employee, but to that other participant residing at a different address. Do these notices apply to non-ERISA plans or non-ERISA companies? It depends on the notice. So, for example, the question makes reference to an SBC. The SBC is absolutely required for non-ERISA plans, and I'm just trying to think. Medicare Part D is. I'm flipping back. Women's Cancer Health and Rights Act is still applicable. CHIPRA is still applicable. Summary benefits and coverage, wellness program. So I'd say, yeah, there's probably most of these notices that are still going to apply to those governmental or church employers out there. Are any of the Section 121 options that were available in 2021 continued to the 2022 plan year? For example, no qualifying event needed to make certain election changes. At this point, no. There's no extension either by legislation or by IRS guidance. I attended a webinar earlier this fall with a IRS or Treasury attorney, and he said, this is outside of my decision making, but I do not anticipate the IRS extending any more of that flexibility. He said the reason that we did this is obviously this pandemic was not necessarily expected by everybody and kind of disrupted everybody of our lives. Now that we've had kind of this additional flexibility for 2 years, I know that we're not out of the pandemic, but it's kind of his expectation, this attorney's expectation, that people are now able to kind of plan more appropriately going forward, and it's kind of not this unfair surprise, if you will. Will the extension of COBRA election window based on the CAA? Who should be seeing OE COBRA packets? So I think these are two questions. First of all, the COBRA election extension of COBRA elections was not made by the CAA. It was made by the Departments of Labor under some ERISA statutory authority that they have, and they can extend it during any presidentially declared national emergency. I think that falls under certain sections of the Stafford Act. And really, they can extend these deadlines for at least 1 year. In early 2021, the Department of Labor, I think, unfortunately, at least from an administrative complexity standpoint, came out and said, we're going to extend all of the deadlines for the greater of the kind of the outbreak period, which will end 60 days after the end of the president's nationally declared emergency. For the longer of that period, or 1 year, but it's going to be measured from the original date of the deadline. So if my, qualifying event, happens, today, I would have 60 days to elect COBRA. Well, that 60-day deadline is going to be extended to the earlier of 1 year or the end of the outbreak period. We did recently, just as of Monday this week, the IRS last week or a week and a half ago issued some additional guidance on how the initial payment, initial COBRA election extensions will run. We did a client alert of that. That's available on our website. Who should be receiving OE COBRA packets? If they're not currently enrolled in COBRA, I don't think you need to send them the open enrollment packets right now, even though they may still be able to elect COBRA under the extension. But you certainly should be sending it to those COBRA participants who are enrolled in COBRA and are be able to continue on past the open enrollment period. Specifically, we have clients asking if notices need to be provided to participants who terminated back in 2021. And I'm thinking that this has to do with the COBRA election notices. And arguably, yes, if you haven't provided them their COBRA qualifying event or election notice yet, that needs you need to be doing so, even though they have this extended period. And arguably, if you haven't provided that yet, their 60-day deadline, even though their coverage terminated, arguably wouldn't start running until you provided that notice, that COBRA qualifying event notice. With that, it looks like that's all of our questions. We really appreciate everyone joining us today and participating in our survey. And we will plan on seeing you next month. Again, that date would be November 17th. Thanks, everyone, and have a great month.